Welcome, everyone. On behalf of Financial Poise and our panel today, Richard Claywell, Janelle Dressen, Natasha Escobedo, and myself, John Levitsky, we welcome you. We're glad you're here, whether you're on demand or in person today at our premiere episode. Today is a Financial Poise educational program. And before we get started, we'd like to do a few administrative things. One is if you have any questions that you'd like to email any of us about, any of the four of us, our emails are in the deck that we have provided as materials. And the materials are there for you to use as supplement to what we've talked about. Some additional explanatory content is there, and please feel free to take notes as you go along. But we're not going to flip through the slides. Today is going to be a conversation, a dialogue with the four of us. All of us have experience in business breakups of a variety of ways, everything from valuation and forensic accounting to litigation, trial and negotiation. And the administrative items I'd first like to take care of are thank yous. Thank yous to our sponsors, Mood. Also, thank you to our sponsors, Sunburst Type to Learn and Max Asset. And today is intended to be an open, free-flowing discussion, but it is not advice. If you would like specific advice, seek an appropriate professional. We're all professionals in our fields, but we're not here to provide you any advice to specifically rely upon for any purpose. So keep in mind, this is for general information only. And it's my pleasure to introduce more specifically our panelists, Richard, Janelle, Natasha, and then also myself as the moderator. So first, Richard Claywell. Richard, his contact information is here. He's with the firm of J. Richard Claywell CPAs in Houston. Janelle Dressen. Janelle is the managing partner of the law firm of Anthony Ostlund. She's based in Minneapolis, Minnesota. Natasha Escobedo. Natasha is based here in Chicago. She's a CPA and does valuation work. So does Richard, who I mentioned a moment ago. And myself as the moderator, I'm John Levitsky. I'm also a CPA and I do valuation and forensic accounting work. Today, we're going to talk about business breakups. Primarily, we're going to talk about business breakups in the context of closely held and private companies. There are a lot of challenges. We're going to talk about legal. We're also going to talk about motivations, both economic and legal, and we're going to talk about valuation and forensic accounting aspects. This is part of the complex financial litigation series by Financial Poise. If you look in the deck of materials or on the Financial Poise website, you'll see a list of the other topics in this series. And so we're going to start with episode 1 here. And I will just leaf through the deck just for the purposes of showing you there is additional information here that we think you will find helpful. The deck continues for several pages. And if you'd like to ask us any questions about anything we talk about or anything that is in the materials that we haven't touched on, please feel free, as I mentioned, to email any of us. So with that, I am going to start the program by turning to Janelle. And we're talking about business breakups, and we've heard terms in the marketplace like business divorce and oppression and dissent. What are we talking about when we say a business breakup?
Well, I think thanks. First, I'll say thanks for having me today, John, and Financial Poise. I think business breakup is really self-explanatory in many ways. As you mentioned, I think it can also be referred to as a business divorce. And oftentimes this is a lot like marriage divorce, where it's essentially the business owners need to be separated, which can occur for many different reasons. I kind of like to put it in 2 different buckets. It may be voluntary reasons they want to separate. Maybe it's a result of retirement. Maybe it's a result of they want to sell the business. More often than not, it's involuntary, and there may be a whole host of involuntary reasons where it truly is what you think of kind of as a breakup or a divorce. Sometimes, some owners want the separation and others don't. And so this can be a very hotly contested, can end up in litigation, can involve many disputes, and can be very emotional, like a traditional divorce might be. Only difference is they're not fighting over custody of children.
Well, thank you. Natasha, failing businesses. What is a failing business, and are there some telltale signs or some examples in the marketplace?
Yeah, well, I'll just echo what Janelle said here. Thank you for having me today to start. And yeah, a failing business is basically a business that is in danger of not being able to continue as a going concern. And there are some warning signs to look out for. For example, one of the biggest ones would be declining revenues. If a business is consistently experiencing decreasing sales over time, that is definitely a sign of trouble. It could be due to not paying attention to market changes or changes in competition, or perhaps a decline in the demand for that business's products or services. If a business has cash flow issues, if they're having difficulty paying bills, suppliers, paying their employees on time, that would indicate a cash flow problem. Even if a company is making sales, if they're not managing their cash flows effectively, that can lead to financial distress. Another really important sign would be accumulating debt, and that's a warning sign. For example, here, if the business is borrowing to cover their operational expenses as opposed to borrowing for growth opportunities. And if that's the case, if the reason they're borrowing is just to cover operations, that's a huge red flag that there may be some inability for the company to continue as a going concern. If the company is losing key customers, if they have customer concentration and they lost one or more of those key customers, that can be a sign of distress. If the company isn't adapting to changes in the industry at an appropriate pace, that can also result in financial distress. Another less thought of example, but one that is also probably a good sort of canary in the coal mine, is high employee turnover. The company doesn't have the ability to retain quality talent. Then that can also be an indicator. Let's think of if there's anything else. Does anybody, Richard, do you want to add something here?
Well, a lot of times people don't understand what you just said. And
Sure.
I understood every word that you said. What I would suggest that people do is understand how ratios work, and get in touch with their CPA if they don't know how to do it. Have the CPA teach them what these cash flow ratios are about, and try to monitor those things. I mean, I understand when the revenues go down. I mean, that's obvious, but if I'm busy and I won't have time to mess with it, I don't notice that. But if I'm getting a report every month and I like graphs, then you start to see that stuff that starts to hit you between the eyes. I've got a problem. You got the problem. You just don't recognize that you've got it.
Richard, I love that you said that, because, as business valuation experts, analysts, one of the first things we're going to do is ratio analysis. We're going to look at common size analysis. We're going to look at the financials over a historical period. And the other thing we're going to do is, very likely, we're going to do some benchmarking to industry standards, right? And also, as experts, the other thing we'll do that I didn't mention before is we're going to inquire as to whether there are any legal or regulatory issues, whether there's any pending lawsuits. That would be a huge red flag indicator of financial distress, potential financial distress as well. So I'm glad that you mentioned that education piece is really important because we understand how those financial
Right,
ratios work, but we would have to explain that to a client.
that's right. I agree.
Sorry, my mic was on mute. Natasha and Richard is a follow-up. Some of our audience may be familiar with the television program Shark Tank. And a lot of times they're investors that come out, and then one of the sharks on the panel, Kevin O'Leary, will ask a very pointed question and say, well, it sounds like you have an interesting idea here, but do you really have a business? And tell me about cash flow. And so is that in essence what you're getting to when you start talking about financial ratios? Is cash flow one of the important things in a business?
Well, John, I think Richard will agree with me here, possibly, and if he doesn't, I'll be really interested to hear his explanation, is that business valuation theory is premised upon this idea that the value of a business is the present value of that entity's expected future cash flows. And so it doesn't really, in some regards, it matters, but it doesn't really matter how the company has performed historically if cash flows are expected to decline significantly in the future. So when we're valuing a company, it is very forward looking, right? And so the expected future cash flows are hugely important. Richard, do you want to add to that?
I will. When I read textbooks about valuations, and that's what we do. You go to webinars, you go to seminars, and you talk to other people. There's always a phrase that always comes out, and that is cash is king. and without the cash, just close the doors and go home.
From the lawyer's perspective, it's follow the money.
There you go. Same concept, yeah.
Well, thank you. So, Janelle, we've talked a little bit about what a business breakup is. What are some telltale signs of a failing business? What are some reasons in your experience that a business breakup might occur?
Well, as I mentioned, I kind of put into two buckets, the voluntary and involuntary, but the involuntary is where I end up spending most of my time and perhaps where if you're testifying in court, it's generally an involuntary situation. It may be, death, certainly unexpected death in particular, or disability of an owner. And I should preface this by stating we're talking about private businesses here. We're obviously not talking about public companies where shareholders can go and just sell their stock on the marketplace when they want to. So this is where they're, I don't want to say stuck, because there's certainly methods and agreements and processes and statutes and so forth that can get a business owner out of the company. But absent that, if something unexpected happens, their shares could be trapped in the company, and death and disability are some of those circumstances. Employment termination, that could be involuntary if it's not a retirement. And oftentimes in these businesses, the owners are employed and are working for the company. It could, what I see oftentimes where a business breakup originates is fight over control or the business direction. One, if it's a smaller company or a small number of shareholders, and one group of shareholders wants to go in one direction and another group of shareholders wants to go in the other, that can create certainly a significant reason for there to end up being a business breakup. And oftentimes what you see is you may have some owners who want to grow the company and they want to reinvest their profits. And then you have other owners who may want to take the profits out and use it, as part of their investment for something else. Therein, you have a huge business dispute, and the calmness that maybe existed when they became business partners no longer exists. So those, the other one obvious is if there's self-dealing, or you have a fraudster involved, you have somebody committing bad acts, a bad actor. Obviously, in those circumstances, the good actors or the good partners do not want to be partners with the bad actor. If you're stealing or you're taking excessive comp, or sometimes you're bringing in family members, or you're running all your personal expenses, which we actually see quite often. You're running all your personal expenses through the company and treating it as though it's, you're paying for cars, you're paying for vacations, et cetera, et cetera. Those can all be examples of reasons that business owners would want to break up, if you will.
Thank you. Richard, along the lines of what Janelle mentioned, she said, when the businesses are formed, there may be calm. And also I would guess that sometimes there's positive energy. There's some reasons that the owners came together to form or buy a business. But things change over time. And are there certain things that businesses could plan to try to avoid the extreme outcomes of a business breakup?
There are, and let me make a comment that Janelle covered a lot of good things and had a lot of good comments. One of the issues when we start a business with somebody else is looking at where do we want to go? I want to grow the company and you just want to take cash out. So we need to sit down and have a talk with everybody. What are the goals? What do we plan to do and how are we going to get there? Those need to be discussed. Another thing is a lack of advice that we get. We're starting, and Janelle made the comment, we're not talking necessarily about public companies, but these are smaller, closely held company types of things. And small could be, $20-30 million in revenues. But we don't want to go pay Janelle. I mean, she's a lawyer, she's expensive, so, I can figure this out myself. I think that is one of the number one hazards for starting a business. You've got to get in touch with a lawyer. I mean, these people are educated on how to set these businesses up, how to handle these problems, and they'll look you in the eye and tell you, if you do this, this is what's going to happen, and you need to be aware of that sort of thing. So same thing with your CPA, same thing with your business valuation advisor, or your financial advisor. You need to talk to these people and get their advice. We've been down that road many, many times. I mean, everybody on this phone call has done this sort of thing more than once. We've experienced this. We've been there. We've done that. So get their experience, the costs. And I made the comment, well, gee, Janelle's a lawyer. I'm not going to go pay her whatever her hourly rate is. It's too expensive. But I will guarantee you, if you don't do that, somewhere down the road, you're going to decide that you're going to split the blanket and everybody's going to go their own way. Whatever you would have paid her at the beginning will probably double, triple, or quadruple in costs to fix the problem that you didn't do in the first place. So I can't stress how much it's the importance of talking to attorneys, talking to CPAs, getting that advice. It's going to cost you some dollars, but you really need to do that. One of the problems that I see is handshake deal. You and I agree we're going to start this business and here's what we're going to do. 4 or 5 years later, well, I don't remember saying that. And so now we've got a problem because it's not documented any place on what's going to be going on. So avoid the handshakes. I understand it. I've known my friend for years and years and years. I trust him. And Janelle made a comment a while ago about fraud issues. Well, just because I've known you for 20, 30 years doesn't mean you're not capable of committing fraud. So document this stuff and what's going to happen with this. We also have operational distractions, and she made the comment, one person wants to go one way, another person wants to go the other way. As the business starts to grow, and this kind of goes into what she's talking about, there's an opportunity to, quote, branch off and do some other items that we really hadn't thought about at the beginning. Well, I don't want to do that. I want to do the original thought process of this particular business. So now we have problems with each other. We also have, unfortunately, relatives, spouses They are providing input into what's going on. They don't like whatever. And so now I'm getting pushback from my wife because she's saying, well, I don't want to do this. It doesn't bother me that much, but her it bothers. So now I have to contend with that. Uh, it gets to be stuff that you really need to talk about at the get-go, get it resolved, get a document and put it in writing that here's what you're going to do, and pay those fees that you don't want to pay now. It is well worth the investment.
So Richard, so for a successful breakup or a breakup that's less painful, is which one of the things you just mentioned, is that's what you might call a buy-sell provision? And what is a buy-sell provision? And if there is one, where would you find it?
There's a thing called a buy-sell provision, and what that is, it's a legal document. I would not recommend that you try to do this yourself. You need to go to an attorney, but it deals with what happens if somebody wants to get out of the business. Are you going to sell the business for cash? Are you going to take a note on that? What's the business worth? Natasha made the comment a while ago about valuing businesses. What is the fair market value of that? So now we have the issue of, look, I want to get out because I don't like you anymore, but I want to get a fair price for it. So how am I supposed to determine what that fair price is? So you need the attorneys to draft this thing and tell the attorneys how that is going to work. Am I looking for fair market value? Am I looking for, we've agreed we'll just sell it for 1 times the revenues, whatever it happens to be. But this will dictate the terms on how you can actually separate. It makes it a lot easier because now we know exactly what needs to be done. When you value the company, you can go back and look at what the attorneys have said or what the agreement says that we're going to do fair market value. I would recommend that when you do the buy sell, from what I do for a living, is basically state that you're going to do it at fair market value. You may or may not have some discounts involved with that. Address that issue. If you're not a controlling shareholder, there are some discounts that relate to that. Do they apply? Do they not apply? So now we get into a different standard of value. We have fair value and fair market value. Which one are you going to do? And if you don't address the issue, the fight's going to be longer, i.e. it's going to cost you more money. And the quote expensive amount we paid Janelle at the beginning is going to seem minuscule because of the fight that's involved, because you weren't aware of what needs to be done.
Well, thank you. Natasha, what about in a breakup? A lot of businesses that are closely held try to keep their operations under the radar, or how they do things, not publicly known as a public company would. But when it comes time to break up a business or separate owners, is there a cleanup or good corporate hygiene that becomes an important factor? In other words, how do they make a clean break?
When you refer to corporate hygiene, John, when I think of corporate hygiene, I define that as all of the business practices or the practices of that business that promote transparency, accountability, promote ethical conduct, and most importantly, promote the sustainability of the business. So when thinking about corporate hygiene, I'm not sure if we're thinking about it the same way here, but I'm going to answer it the way I'm thinking about it. And when I think about good corporate hygiene for a business, I think about all of the protocols that are in place to help that business, for example, comply with laws and regulations applicable to that particular industry, to that business. For example, labor laws, environmental regulations, tax compliance, or industry specific regulations. And if a business isn't doing that, their sustainability is at risk, right? And oftentimes those are the harder things to do for a smaller or medium-sized business that's focusing on generating revenues, generating business, generating growth, right? So it's all of these administrative things that also need to be considered. I also think about good corporate hygiene in terms of maintaining crystal clear, transparent financial reporting. It's pretty rare that I'm valuing a small or medium-sized business that has audited financial statements, let alone, reviewed. Sometimes they'll just have a compilation, and the quality of financial reporting often leaves a lot to be desired. Richard, I don't know if you would agree with that. And so having really good financial reporting in place is important for making the exit as clean as possible. Typically, I would say 95% of the time, the historical financial statements require some sort of adjustment for non-business related expenses, non-operating assets, things that shouldn't be part of the financial statements. And so if you don't do that to begin with, and I know that's asking a lot of small and medium-sized businesses that, aren't required to be audited. But if you're exiting and you're trying to get out of the business cell, and you've done this, you have to expect that the evaluation analyst is going to make adjustments for that to show how the business would have performed absent those things. I also think it's really important for a business to think about their corporate governance, who's sitting on their board, who has the ability to make oversight decisions, and how is oversight being conducted. So those are some of the big things I think about when I'm thinking about how a business can set itself up to be in the best position, how a shareholder can be in the best position to exit smoothly. Are these things relating to the business clean and up to date, and are they in compliance?
Well, thank you. Janelle, when there's a dispute, say between owners and either an actual business breakup or one's demanding a business breakup, does everything go to litigation in court, or might there be times when there is guidance from some sort of agreement? And are there other options, or are there other requirements like arbitration?
Yeah, it doesn't necessarily have to go to litigation. I mean, the first thing I ask my clients is send me all of your shareholder agreements. That also will include send me your articles and bylaws. Once in a while, you find some unusual provisions even in those documents. But so you want to look for the dispute resolution provisions in any documents that the parties are party to. I even ask for if there's employment agreements, because a lot of times there will be detailed employment agreements, and employment issues come up all the time for business owners in business breakup disputes. So I asked for these documents, and one of the things I'm looking for is, are there arbitration provisions? Sometimes there's a provision first that requires mediation between the parties, which is essentially a sit down with a third party to try to negotiate a resolution. It's not binding, but it's intended to avoid litigation. And arbitration, I view that as a form of litigation. It's just you're not going to court. It's with a private decision maker. And there can be, I've seen all sorts of different arbitration provisions. But there's also can be provisions about just separating. And it might not even be in, if you're looking at your contracts, it might not be in a provision that says arbitration or dispute resolution. It might be in the buy-sell provisions of your agreement that it may, sometimes it's called a baseball arbitration, which essentially is both sides, if you will, or both owners are going to make a proposal to a third party who's considered the arbitrator of what the terms and condition and price should be, and the arbitrator decides, and it's binding. And so, and you're either the buyer or seller at that price. It works great to avoid litigation. It's obviously a very high risk proposition, based upon, and really the intention of a provision like that is to entice the parties to being fair and reasonable when they make their proposal. Another type of provision that I've seen, it's called the Texas shootout. I don't, in this day and age, really like using the shootout analogy anymore, but that's where it comes from. So, but in that situation, and I actually just had a case that went on for a couple of years where there was this provision that allowed any owner at any time to make an offer to the other owner, and under the term of the offer, it was a lump sum, it had to be a lump sum offer to buy his shares. The other owner could either be the buyer at that price or the seller at that price. And of course, they had, so many days to respond to the proposal. And if you don't respond, you're considered what the original offer is. So in this circumstance, he made a proposal to sell his shares at X price, and the other owner said that she wanted to be the buyer at that price. So and then it's binding, and the parties had a hard time getting closure on it, and the court enforced that provision and ordered specific performance and made the transaction occur. Another provision that I've seen, in this one I haven't seen in any other agreement, but I thought it was an interesting way to solve disputes. And again, I put this in the category of maybe high risk, but also intended to avoid litigation. It was a roll the dice, where the business it was a real estate company, and the owners at the beginning, when they entered into this agreement, became owners together, decided that the company could not afford, they didn't want to have the company pay, and concern about the company affording a buyout of more than one shareholder at a time. So there would be a certain time period at the end of each year that if a shareholder wanted to be bought out, they provide an election notice. And if more than one shareholder provided their election notice that they wanted to be bought out, they would actually roll dice, and whoever had the highest number got to be bought out. Of course, there's a formula, price, and terms under the agreement that they'd be bound by, and significant discounts applied and so forth. So there are all sorts of creative solutions that lawyers, I think, have come up with, can come up with, where it's more of a binding kind of separation, rather than having to go to litigation and have a judge just decide who knows what, when, where. And what's important in having in those provisions, though, is making sure that you have the bases and details covered and it's not ambiguous. Because if it is, you end up fighting over what the meaning of the provisions are anyway, and you still end up in court. So I want to go back to something that Richard said, which is I don't draft these contracts, I litigate over them. So this is not a plug for myself, but it is a plug for lawyers who draft these documents. I think it is such money spent to hire a good lawyer to have these documents drafted, even if you don't get them done when you form your business. If you don't have them and you've been in business together for 10 years, go get them done. And have a lawyer who knows what they're doing. I would also consult with people like John and Richard and Natasha on the valuation and formula provisions, because what happens in these matters when we get into a dispute is we turn and as the lawyers, the clients, we look to them and we say, okay, value the business. And they have 10 unanswered questions of, well, what valuation method do I use? How do I treat goodwill? Do we apply discounts? Is it fair value? Is it fair market value? There's a number of questions that can be answered by the parties and they can agree upon. And then there should not be such a wide range of valuation opinions from when you're getting the appraisal portion of it to determine value.
Well,
Let me
thank
make a
you.
comment about that real quick. In my practice, we deal with CPAs all the time because we're getting records from them. And what I tell my staff is not all CPAs are created equal. And that actually applies to attorneys as well. And I say that we have a shareholder dispute we're working on now, just getting ready to get started on it, talking to the client. They picked a guy that somebody had recommended as primarily a real estate attorney.
Mm.
And I'm thinking, this is gonna be fun. So, you're 100% correct. Find people that have done this more than once, that understand what's going on. It's well worth it.
Yep.
Well, Richard, let me ask you a question about if you're doing evaluation and say you have good agreements to go by and it's a private company compared to public companies where there's a lot of disclosure and there may be a greater investment in management and oversight. Uh, in a closely held company, when you're valuing it, how do you know what you're valuing? In other words, like if there was a sale, so if the standard was fair market value, which is value in exchange in large part, uh, is the goodwill transferable? Do the executives continue to work, or do the executives leave and compete? Are there some key things that you would need to know to be able to actually do evaluation that might be helpful to know in addition to just what the standard of value may be?
There is. When we do our valuations, and everybody's gonna do them a little bit different, and that doesn't mean that it's incorrect. It just means that, the glasses I look through are a different color than the glasses you look through. That's all that means. But we have about 30 questionnaires that we send to clients, and people that I know say that's too excessive. But we're asking for what's going to happen. What are you trying to do? Who is the management? Who are the employees? Are the employees related to the owners? Just what is actually going on? If you're gonna buy out somebody, and I'm going to take, for the sake of argument, I get $10 million for this, and the company doesn't have $10 million in cash, which means you haven't done your planning to figure out how this is going to happen, because it's going to happen to you. Then, how do I guarantee that I'm going to get my $10 million? How do I know that you're not going to file for bankruptcy next year? So we need to find those things. And what we're looking for is risk. When we value a company, what we want to do is determine a thing that's called a discount rate. So if you go through the process, you'll hear your valuation person talking about a discount rate. You'll hear your attorney talking about a discount rate. That is measurement of, or an assessment of the risk associated with the cash flows that you're going to be generating. The higher the risk, the lower the value. The lower that risk, the higher the value. So that's an extremely important number. So we have to be able to support that. Now, we do a lot of litigation work, and we're challenged on that issue every time we go testify. So it's really no big deal. You just know it's going to happen, but you need to be able to support what that is. So if you're going through this process and somebody says, well, your discount rate is going to be X. How'd you get X? It's difficult, I think, in an agreement to try to define that, but you need to know what that answer is. If I have a discount rate, say of 25%, just for the sake of argument, why is it not 30? Why is it not 20? Why is it not 24? Find out what's going on with that and how that's developed. But that's where we ask a lot of questions. Our questionnaires that we send out, you expect me to do my job, and I expect you to do your job. We're going to send you the information requests and document requests, and we expect you to answer all of our questions. And if you don't answer all of our questions, we're going to bounce it back to you and say, you didn't answer question number whatever happens to be. So it's just a matter of the evaluation individual doing their due diligence to get as much information as they possibly can.
So Natasha, if I could ask you a follow-up question that relates a little bit to what Richard said and also what he just answered and what you'd answered before about corporate hygiene. If you're valuing company A and versus company B, and company B owns its intellectual property, it's registered in its name, company B, it has management contracts in place with its key executives, and its key executives are not towards the end of their normal work career. But company A has no contracts with its executives of a long term, and some of its executives that it's critically dependent on are getting near the age where they may be looking to retire. And company A, as it turns out, their intellectual property, it happens to be in the name of the original founder of the company, the grandfather, but there's no contract with the grandfather. So does that two different fact scenarios make a difference in value? And perhaps just ask Janelle too, might that lead to some things that need to be resolved as part of the dispute?
Yeah, well, it would definitely be a qualitative consideration, and to the extent that the nuances of each scenario affect the timing and amount of expected future cash flows, that very well could affect the valuation outcome. That would be something that would be discussed heavily during management interviews and other management interrogatories, perhaps. So, the short answer to that is, yeah, we would definitely want to know and dive into all the details pertaining to how each of those scenarios are expected to affect the future cash flows of that entity. And it could very well have a significant impact on the valuation outcome.
And Janelle, you sometimes find that when there's a business breakup, that the company doesn't have all the assets like intellectual property or contracts with management is under control is what might be ideal. And is that sometimes an issue?
Yeah, I mean, unfortunately, I would say it's more often than not. A lot of these companies have operated very informally. I think, they get together, they have an idea, it takes off. All of a sudden, they're successful and they're busy running the day-to-day, not thinking about these kind of details. Certainly not thinking about what's all the documentation, because that seems like a nuisance, I think, to people who are salespeople and operations people, and how do we make money, and spending time getting the correct documentation in place and contracts in place, and even honestly, the financial statements in order. A lot of these business owners, it's just in their head. They just know it. They know what they're selling, they know what they're receiving, and they don't need to necessarily, at least in their minds, see it on paper. But of course, when you get in this situation, you end up in litigation or in a business dispute, what's on paper can largely control. It is definitely the more persuasive evidence. And then I'm communicating with people like the three of you, trying to figure out the value of the business, because that's best how I can advise my client on potential outcomes. And you're looking at the details and the financials and the contracts, and you're saying, we can't make sense of this, or we need access to management. And my client may be the one that's on the outs, and I don't have access to management, or I don't have access to all the documents or all the answers. And because things weren't documented very well, it can make it very challenging for the three of you to do your job, certainly. But then that also makes it very challenging for me to do my job, to advise the client what to expect, and what potential outcomes are. And as we were having this discussion, I have a question for the three of you, if that's okay, which is, because this comes up often. I have clients that do business projections as part of their business. That's just standard. They do it annually. Sometimes they might do it more than annually. And then I have clients that have never done a business projection ever. And obviously that can become relevant, especially if you're applying the discounted cash flow method to the valuation of the business. Do you have a preference as the business appraisers for your clients to have done their own projections, or what's your feelings on that? Because I think that is something that clients really could be a lot better at.
Yeah. I typically prefer to have the projected financial information forecast or projections prepared by management of the company. There are numerous instances where I'm valuing a smaller company and they don't do it, and then I have to do that on my end with their input. And either way, no matter whether it's prepared by me and my team or prepared by them, we're still going to go through and look at every single assumption in that projection to see as to whether or not it's reasonable. And there's two things that really are important when considering the projections is if they're not reasonable, you either have to adjust the projections or adjust the discount rate. And some professionals think it's better to adjust the discount rate and leave the projections as prepared by management, and others will argue that it's better to adjust the cash flows themselves to a more achievable level. And that's going to vary by professional, but I prefer to have to start with something that management has prepared. What do you think, Richard?
It's an interesting question. I've been doing this for 37 years. And in that time period, I've only had one person that really understood what the DCF, discounted cash flow, was about. They were doing some estate and gift work, and this was for his mother. He was an investment banker. He knew what to do. He did a really good job on it. That's one out of, how many thousands that we've done. We had another one a few years ago, and it's management's responsibility to do this. And I've got a client right now that about to drive me crazy, trying to get some projections on this darn thing. But this was for litigation. The individual in-house had a CPA that worked for him, and the CPA said that he could do the discounted cash flow or make the projections. And I said, that's fine. As long as they're good, then we'll do that. So we got them the first time around. I looked at them, just like Natasha says, you go through them. Is the theory right? Is the math right? Does this thing make any sense? And it did not. So I bounced it back to him and said, here's why this is not going to work. So the CPA did it a second time, got it back, didn't work. So I bounced it back. And again, I'm telling them what they need to do to get this thing where it's reasonable. They did it a third time. It didn't work. Well, now everybody's starting to get upset because it's taking so long to get this thing done. And in Texas, they have a thing called Rule 11 agreement. And that's just where everybody stipulates that this is what the answer is going to be. So they didn't want to pay me to do the projection because this guy had already done it 3 times. Had to wind up, they agreed that we would use the third set of projections. They weren't the best. They were a lot closer. But they did a Rule 11 agreement. They took it to court, had the judge sign off on it. And what that sign off was, we're going to use this third projection. The numbers are not necessarily correct. However, you will not challenge me on those projections. And everybody agreed to that. We took the guy's numbers and went from there. But it took him 3 times and the numbers still weren't correct. So it's a problem when they try to do it themselves. And I made the comment a while ago, not all CPAs are created equal, and they're not. When we go to school to learn how to be a CPA, they don't teach us that kind of stuff.
Yeah.
It's something you have to learn once you get out of school. And if you're not, I mean, we do it all the time. We do discounted cash flow probably 99.9% of the time. I feel very comfortable doing it. But if you don't do that sort of thing, you're in new territory. You just don't know how to handle a lot of different things. So it's problematic when they try to do it themselves. It's their responsibility. So we just kind of walk them through the processes of what we do.
Well, thank you. Natasha, a while ago, Richard mentioned majority and control and whether or not, depending on the standard of value, discounts might apply. Well, with majority control, are there sometimes allegations of shareholder oppression by the majority shareholder? And if so, from a valuation or a forensic perspective, are there some financial elements that you may look for regarding shareholder oppression?
Yeah. Okay. So I think what you're asking me here is, what are some of the things that I would see as manifested in the financial statements and or operations of the company that would be indicia of shareholder oppression? And so, wh- w- some of the indicators of shareholder oppression would be, for example, a dividend policy that favors the majority shareholder over a minority shareholder. So, for example, disproportionate dividends, either whether that was transparent or hidden somehow. We see that a lot. A lot of the litigation matters that I've been involved with have involved some instances of disproportionate or inequitable distributions. Um, in that the minority shareholders weren't getting their proportionate share. A lot of times, majority shareholders will take leeway in engaging in related party transactions. They may have a side entity that they use as the vendor, so they're utilizing their own side company as a vendor, perhaps, or a supplier, and getting money out of the company that way. And that transaction may or may not be at an arm's length, may not be at like what you would pay to a third party, maybe quite more. So that's another way in which a minority shareholder would be oppressed. A majority shareholder could also take out excessive executive compensation, and this is an adjustment that's commonly made when doing evaluation. We would look at the historical compensation that's been paid and make an adjustment as appropriate to a market level. If, for example, and I've seen it both ways, where an owner shareholder has been overpaid and or underpaid. Let's see. I'm looking at my note now. Another example would be where the controlling shareholder has voting rights, but the minority shareholder doesn't. And that can significantly affect the value of that minority shareholder's equity interest. If they can't vote on any of the important matters pertaining to the company, that diminishes their ability to influence the direction of the company and make some of these other decisions that directly pertain to how the cash is utilized and how the value is maintained within the company.
Well, thank you. Janelle, you have a large amount of experience litigating and resolving business breakup, business divorce, and valuation disputes at trial and arbitration and the like. Is there an example from the last few years of a case and a decision in a matter you handled you'd like to share with us?
Sure. I had a case that actually started in 2017. We tried it in the middle of COVID, and it was a 4-week trial by Zoom. It involved a business that was owned by 4 family members. So it was a mom and a dad and a son and a daughter. The daughter was the oldest. Daughter did not work in the business. Son did. This is a very common setup. But they were all 4 shareholders. Mom did not work in the business. Father founded the business. It's very successful. It was sold for over $1 billion. So now this family of 4, the children are, in their late 40s, early 50s when this happens, are sitting on $1 billion. And the father and son receive large transaction bonuses. The sister sues, saying that's shareholder oppression, breach of fiduciary duty. the bonuses were excessive. It was a, stunt to avoid paying her more shareholder distributions. And she brought a whole bunch of other claims as well. And this case went on for a very long time. The complaint was amended multiple times. Ultimately, the court dismissed these bonus claims as being derivative. But then she brought, some additional claims that she alleged were disguised distributions and all sorts of things. And this was, a shareholder who had received over $200 million already in distributions. And keep in mind, she inherited this interest from her mom and dad. So very contentious matter. It's actually still pending in that we have it decided that the court issued a 385-page decision. So it covers all sorts of issues for anyone. It's a public order in Minnesota State Court. So anybody that wants to read the novel, it's certainly available. And part of the dispute certainly was valuation. Valuation experts testified, but ultimately the court concluded that the business could wind up. It owns some other assets after the sale of the main business. It's in the pharmaceutical business. And the court also ordered payment of some additional distributions to the sister. So it's possible the parties are going to appeal. That's why I say it's still pending. Those deadlines haven't come yet. They're sometime in March. So it's a very extensive decision. But what it tells me is that even in cases of, where somebody's received, I think everyone can agree, more money than you could ever spend. And even in the context of an inheritance, and we had a buy-sell agreement. And, even in the best of intentions of the parents, you can still end up in these disputes. And it certainly has torn the family apart. It got lots of press coverage in Minnesota. It was on the front page of our newspaper here many times. And so I would say this, that no matter what you do, you can still end up in litigation. And this was a case where we did not have any of these kind of fallback provisions in a buy-sell agreement that I was mentioning that might take care of this, so that this can't happen. It illustrates, again, that even in the best of intentions, and even when a shareholder has received over $200 million, you can still end up in extensive litigation if you don't have kind of the end-all be-all provision in your agreement. And they just didn't have that here. So.
And Janelle, what were the nature of the legal claims? Is it fraud or fiduciary duty?
Breach of fiduciary duty and shareholder oppression. Yeah, and her shares were held in trust. That's very common for these wealthy family business owners. They hold their shares through trust. So she also did pursue claims against her trustee for breach of fiduciary duty, for the way he did or didn't vote her stock. So, but largely, I would say that the case centered around breach of fiduciary duty, and ultimately, while we'd like to say the fight was about money, and it always tends to be about money, these cases also center on control. And in this case, you could argue there is who knows what happened when these kids were 4 and 6 years old, and jealousy and all the emotions that go along with brother and sister and mom and dad, and son was in the business. He ended up being the president and CEO of the company, and daughter never worked in the business. So there's all of that gets wrapped up, and that emotion can take over pretty quickly.
Thank you, Janelle. Well, at this point, we have come to the conclusion of our hour, and wanted to thank our audience and also thank our panel. So on behalf of Richard Claywell at Richard Claywell CPAs, Janelle Dressen at Anthony Osland, and Natasha Escobedo with Epstein and Knock, and myself, John Levitsky at HKA, plus Financial Poise, we thank you for joining us today. We really appreciate it. And please feel free to reach out to any of us with any questions we have. And we invite you to join Our future programs, there are several each year. You can find them on the Financial Poise website. We look forward to seeing you again. Thank you all. Bye-bye.
Thank you.
Thank you.
Appreciate it.